Okay, welcome to this first in a series of Free Hair Court webinars under the title International Commercial Disputes and Arbitration. They're going to be fairly short seminars containing tips and tactics from myself and my guest speakers, as well as relevant updates on pertinent issues of law and so on. So today we're going to be talking about interim relief and in particular freezing orders. Today, I'm very pleased to introduce my expert special guest from Hassan's international law firm in Gibraltar, Daniel Feetham, Queen's Counsel, Senior Litigation Partner at Hassan's. You can give us a little wave, Daniel, so that we know which one you are. Thank you very much. And his colleague, Mr. Darren Martinez, Senior Associate, also from Hassan's international law firm. I've had the pleasure of working with both of these guys on many cases over the years, important, interesting commercial disputes cross-border in the UK and in Gibraltar. So they are ideally placed to give us their perspective today. So freezing injunctions, basic principles, not actually that complicated, but the most important factor and where many parties trip up is to get really good, decent evidence of risk of dissipation, the risk that a party is putting assets out of reach and behaving otherwise, not in the ordinary course of their business. So as to put assets out of reach if you were to secure a judgment in your claim. Second point, good arguable underlying claim. Cross-undertaking must be given in damages, and it must overall be just and convenient to order the injunction. So we're going to focus, I think, gentlemen, on the really key issue of risk of dissipation.
So what you need to establish is a good arguable case of an unjustified, of a risk of an unjustified dissipation. Now, unjustified, we can't really define it because there are a lot of circumstances that apply to the term unjustified. We've recently done a case where unjustified has been in the context of a company that was either insolvent or likely to become insolvent, and dissipation out of that company was held to be unjustified because it was out of a company that was potentially insolvent.
Okay, so in terms of the evidence that we'll be looking to get hold of to establish a risk of dissipation, what tips and tactics do you guys have or have you deployed in recent cases to try and get at that evidence? I don't know, Darren, do you want to come in at that point?
Yeah, so we found that often you get stonewalled by the other side when you're trying to find out information. So you often will need accounts and tangible information that you can put before the courts, tangible evidence, and the other side isn't always helpful, as I'm sure you can imagine. So what we found was quite helpful was to send letters to the other side and get them to try and slip up in their responses, because then this correspondence can very helpfully be put in a bundle before the judge, and you can say to the court, well, look, we've sought this information, this is very serious, and that gets the judge thinking, well, why aren't I being given this information? What's here? What are they hiding? So actually it's a case of, if they don't give you the evidence, then you try and pry it from them and do what you can, and if you can't, you put the evidence before the court, and that's often helpful. It was in our last case. Yes,
and it's got to be focused questions that you're asking. You've got to ask yourself, why am I asking this question? Is this question and potentially the answer or non-answer going to be helpful to me in my application before the judge? And always think about it in these terms. You've got to think about it in terms of judge over your shoulder. So when you write a letter always knowing that that letter is going to come before the court, and it's got to have a purpose. And it's always, you've also got to bear in mind as well that if the other side prevaricates, if the other side misleads or doesn't provide the answer, then of course there are a number of cases that allows you to say to the judge, well, look here, judge, you can draw adverse inferences from the way that they've answered or the lack of answer.
Yes, that's very useful. I'm thinking in that respect, there's the Preston Petrodale case from the Supreme Court in 2012, although in the context of matrimonial proceedings, I have used it certainly, and I know probably you two have as well, in a broader commercial context where somebody doesn't give relevant and important information about assets. You can invite the court, as you say, to draw an adverse inference that actually there has been a dissipation, or those assets have been restructured to put them out of reach of creditors. So that's a top tip. Thank you very much. We're asking for details, aren't we, of accounts, recent transactions, cash at bank balances, any details that would reveal possible diversion of assets.
And in fact, Rowan, as a consequence of the COVID crisis, I think you're going to see more companies that obviously are going to have cash flow problems, insolvency, or the likelihood of insolvency is likely to become more apposite during this time, and more applications are going to be made for freezing injunctions on the basis of payments that are being made out from these types of companies. So I think you're going to see an increase in applications for freezing injunctions. That's the experience that we have here in Gibraltar, even though the law here in Gibraltar has been changed during a moratorium period, 15th of March to the 31st of December 2020, during which time, for example, you can't make an application for the appointment of a liquidator in order to give companies the chance to potentially survive the current crisis. But still, it doesn't change the underlying law. It doesn't change the ability of claimants and applicants to apply to the court for a freezing injunction in order to protect their position. In fact, it probably makes it even more necessary for creditors to consider this type of remedy in the current crisis.
That's very interesting. Well, we'll come back to the issue of the COVID measures in a moment. We're on the subject of insolvency there and the change that takes place as a result in terms of the duties of directors and companies. Darren, perhaps you'd like to outline where we are in respect to the case law.
Yeah, so the position in Gibraltar and in England and Wales is the same in that we follow the English and Welsh common law. And in the recent case that we were involved in, we relied on the judgment of BTI and Sequina, a well-known case, which I believe is currently due to be decided by the Supreme Court. We relied on the Court of Appeal judgment there. The law in Gibraltar and England is the same. In England and Wales, your Insolvency Act, I believe, provides that there are certain codified duties as to when an obligation is owed to a creditor of a company. The position is not exactly the same in Gibraltar in that it's not codified, it's not contained in our Companies or Insolvency Act, but the common law applies. So ultimately the position is the same. And the Court of Appeal in the case of Sequina actually considered whether the trigger for the director's duties to consider creditors is merely at the point of a risk as opposed to when a company is actually insolvent. And ultimately it found that the duty arises when directors know or should have known that the company is or is likely to be insolvent. So that phraseology of likely to be insolvent we found very helpful in a recent case that we were involved in, because with the information that was disclosed to us at the interim stage, the accounting information, we were able to advance an argument that it was or likely that the company was in insolvency at a particular juncture when certain payments were made. And that evidence that we were able to advance to the court was quite powerful, and we found quite useful and actually features in the judge's judgment. Okay, and let's just explain to our listeners why, in terms of establishing a risk of dissipation, it could be helpful to establish that the company is on the verge of insolvency and therefore the duties are changed. Why is that relevant? Well, in our particular case, it raised issues of preferential payments to other creditors. It raised issues which in circumstances where you're dealing with interim relief and the court, the application of equity were very helpful, because obviously you're looking at payments being made which should have been made in certain circumstances. Directors' duties normally, directors owe duties to the company. They don't owe duties to the creditors. Where a company is insolvent or likely to become insolvent, that duty then shifts
to include the creditors, and therefore it gives the creditors the locus to be able to go to court and to say, well, there is this duty to me by these directors because of this insolvency situation. Ergo, if there is dissipation in breach of those duties, then that has to be unjustified for the purposes of the good arguable case in freezing injunctions.
Yes, so in other words, when we are looking at the risk of dissipation and whether the conduct of the company is in the ordinary course of business, the one issue of relevance to that is, well, are they paying out one creditor above or ahead of another creditor, or otherwise engaging in conduct that might ordinarily be justified, but in an insolvency situation is not justified?
Yes.
Good. Well, that's very useful, and some more tips there. Daniel Feetham, talking briefly about the COVID restrictions, can you just identify what the position is in summary in Gibraltar and how that affects this issue?
Well, we've recently introduced an act in Parliament that essentially prohibits the appointment of a liquidator or an administrator, or indeed the enforcement of security during a moratorium period. That's the 15th of March to the 31st of December 2020. Now, of course, because of that, then creditors need to be considering what alternative action can we take in order to protect our position. Freezing injunctions, where there is evidence of unjustified dissipation, is one of those alternatives that creditors can think about. The law here is slightly complicated in the sense that the prohibition of the appointment of a liquidator is across the board. In other words, whether a company is insolvent or likely to become insolvent as a consequence of the COVID crisis, or was already insolvent pre-COVID. So it's designed essentially to be a blanket prohibition. There is also a limit on the powers of a liquidator, for example, to take actions against directors for insolvent trading, what in England would be wrongful trading, but there, that limitation only applies where the company has become insolvent as a consequence of the COVID crisis. So there's a slight difference between both. We think, and in fact we've received a lot of inquiries here in Gibraltar about this, that creditors can look towards civil proceedings and freezing injunctions in order to protect their positions when the alternative pre-COVID might have actually been, well, let's launch into an application for the appointment of a liquidator.
Well, thanks very much. As I think you know, the restricting have to be more acutely related insolvency issues, but we are still facing very much those same challenges. And I would agree with both of you that actually utilising other tools within the machinery of interim relief, freezing injunctions, is assuming a significance and importance. Thank you both much for those top tips and outlines of your experiences. Your contact details, my contact details, will be available on the site, and we'll also follow this up by a short written summary of the principles that we've gone through today and some of the citations to the case law. Thank you both very much.
Thank you very much.
Thank you.